So the legal terms of this presentation will be defined as follows. Commercial law, also known as mercantile law or trade law, is the body of law that applies to the rights, relations, and conducts of persons, business engaged in commerce, merchandising, trade, and sale. 2. Law refers to a system of rules, regulations that govern human conduct and social relations and are enforced by the state. 3. Commerce is the activity of buying and selling on a large scale. E-commerce is the trading of goods and services on the internet. It is also the buying and selling of goods and services or the transmitting of funds and data over an electronic network, primarily the internet. 5. Cybercrimes is any criminal activity that involves a computer network device or a network. It is also called computer crime, the use of a computer as an instrument to further illegal ends such as committing fraud, trafficking in intellectual property, stealing identities, or violating privacy. Cybercrimes, especially through the internet, has gained importance as the computer is central to commerce, entertainment, and government. Most cybercrimes is an attack on information about individuals, corporations, or government. Fintech, also known as financial technology, described as new technology that works towards enhancing and automating the delivery and use of net services. Technology is also the application of knowledge for achieving practical goals in a reproducible way. The word technology is also meant by the application of scientific knowledge to the practical aims of human life. Thank you.
I'm going to be presenting on the aspects of e-commerce. So there are 8 main elements of e-commerce, which are value proposition, revenue model, market opportunity, competitive environment, competitive advantage, market strategy, organizational development, and management team. So there are aspects to consider when selecting for an e-commerce platform, which are security, vendor experience and expertise, support, scalability, and mobile friendliness. There are 6 basic types of e-commerce, which are business to business, which is known as B2B, business to commerce, B2C, consumer to consumer, C2C, consumer to business, C2B, business to administration, B2A, consumer to administration, C2A. Benefits of e-commerce are fast buying process, store and product listing creation, cost reduction, affordable advertising and marketing, flexibility and speed for customers, no reach limitations, product and price comparison, faster response to buyer or market demands. There are also disadvantages of e-commerce, which are the customers have concerns about privacy and security. Some consumers are still worried about giving out personal information, especially their debit and credit cards. There is lack of in-store engagement with customers. There is added cost of operating an online in-store, and the delivery of the products takes time.
So I'm going to unpack the relationship between electronic commerce technology and the law. Now, the relationship between e-commerce technology and the law is an interesting one. It goes beyond protecting e-commerce activities and touches on so many aspects. E-commerce technology has been defined as the buying and selling of goods on an electronic platform using digital devices. Technology provides unprecedented access to information, coordination, as well as communication. While information technology allows for electronic commerce to happen, the law comes into play to sanction and regulate the access of this information. The nexus between law and electronic commerce is that the law gives rights, regulates relations, and the conduct of both juristic and natural persons. Natural persons in merchandising, trade, and sales on a digital space. Furthermore, the law regulates electronic contract validity, proposal of information, and the contract creation between buyers, sellers, and intermediaries. Online platforms provide terms of service, privacy policies, and return policies, and these must be enforceable, which means it must not be contrary to the law. Put differently, the law protects intellectual property, trademarks, data, and privacy. It also addresses issues of products liability, litigation, as well as remedies for breach of electronic contracts.
Moving on from where my learning colleague has left, I'll be touching on the legal aspects of electronic commerce, particularly national instruments or national statutes that governs electronic commerce. I'll also be speaking on regional instruments that speak on electronic commerce. So in Zimbabwe, more businesses are going digital and therefore creating a need for more interaction between the consumer and the supplier online. This has seen the rise of e-commerce, whereby contracts are solicited, offered, negotiated online. E-commerce has, however, arisen with a number of scams, whereby consumers actually do not receive anything after placing an order and paying, or actually receiving lower standard goods than those they had initially ordered. There is, on a bright note, Zimbabwean legislation which seeks to protect the Zimbabwean people from e-commerce scams. One of these, and I'll be putting emphasis on this one, is the Consumer Protection Act. Section 52 of the Act makes it mandatory for online suppliers to make certain minimum information available to their consumers for security purposes. The information includes the full name and the legal status of the supplier, the physical address and the telephone number, website address and email address, and any alternative dispute resolution code to which that supplier subscribed, and how the wording of the code may be accessed electronically by the consumer. In most cases of e-commerce scams, consumers are quick to press the buy button without checking if the supplier is actually provided for the minimum information, security information required for by the statute. It is unfortunate that at present, once a person has been scammed, it is virtually impossible to get his or her money back as a result of the difficulties in tracking those responsible to bring them to justice. So it is wise for the consumer, before engaging into any transaction, to make sure that the supplier has provided the minimum security information provided for by statute. In addition, the Consumer Protection Act was promulgated in December 2019 to address, amongst other issues, the protection of the consumers of goods and services by ensuring a fair, efficient, sustainable, and transparent marketplace for consumers and businesses. The application of the legislative instrument has been broadly crafted to not only include persons or entities whom are required to be registered for the purposes of their trade or according to the dictates of law, but rather the drafters extended such application to persons or entities operating on a profit basis or otherwise. The Act also seemingly has got an extraterritorial effect, as its application extends to suppliers who reside or have their principal office in Zimbabwe or outside the country. Sections 54 up to Section 54 of the Consumer Protection Act speak to the rights and obligations owed to a consumer, including a 7-day cooling off period in which a consumer, without attracting any penalties or without reason, may cancel an electronic transaction. More pertinent to digital marketing tools, Section 54 of the Consumer Protection Act also regulates for the unsolicited commercial communication with consumers. Section 54 empowers the consumer by mandating that the supplier provide an option to opt out of any further communication, and the consumer may also request the source from which the supplier obtained such personal information. In other words, we are saying someone's private information is actually secure. To add, new bills are being introduced which will govern electronic commerce in Zimbabwe. According to an article in the Herald, the Zimbabweans will now find it easier to move safely and effectively into the new age of online business after the cabinet approved the principles of the Electronic Transaction and Commerce Bill. The proposed legislation, according to the Herald, will provide a holistic transaction regime in the face of opening up of markets and the movement of goods and services across the borders. The bill will also incorporate control over the growth of online scams that I've been speaking about and unfair practices which leave the purchaser or the end user at risk. Minister Chiramba is reported to have said that the key issues provided for by the bill are the use and regulation of electronic contracts and electronic transactions. The minister is reported to have went on to say that the bill is going to establish a predictable, accessible, safe and transparent online trading environment which is necessary for e-commerce to flourish. Now allow me to move on to SADC law on e-commerce, particularly the SADC model law on electronic transaction and electronic commerce, which provides for the obligation of the supplier to supply certain security details. Now allow me to move on to SADC law on e-commerce, particularly the SADC model law on electronic transaction and electronic commerce, which provides for the obligation of the supplier to supply certain security details. Now, it is key to note that the SADC approach is not so different from the Zimbabwean approach, if different at all. These obligations mandated by the SADC model law include displaying information on the contact details and securing information regarding the payment system. The section of the model law, I am going to summarize it. A supplier offering goods or services for sale, for hire or exchange by way of e-commerce shall make the following information available for consumers: full contact details, sufficient description of the main characteristics of the goods or services, full price of the goods or services, information regarding the payment system, any terms of the agreement, and that is it. The same section further provides that the supplier is obligated to review the entire e-commerce transaction to correct any mistakes and to withdraw from any transaction before finally placing an order. Section 27 gives the consumer the right to cancel any transaction and related credit agreement for the supplier without any reason and without any penalty, the same as the Zimbabwean approach that I've been speaking about. The only charge, however, that may be levied on the consumer is the direct cost of returning the goods. Section 27, however, will not apply to several electronic transactions, though, and this I shall rush through. For instance, financial services, including but not limited to investment services, the way of an auction. Section 27 will also not apply for foodstuffs, beverages, or other goods intended for everyday consumption supplied to the home, residence, or workplace of the consumer. It will also not apply for services which begin with the consumer's consent before the end of the 7-day period referred to in the section, where the price for the supply of goods or services is dependent on fluctuations in the financial markets and which cannot be controlled by the suppliers, where the goods are made to the consumer's specifications, are clearly personalized by reason of their nature, or are likely to deteriorate or expire rapidly. Section 27 will also not apply where audio or video recordings or computer software were downloaded for or unsealed by the consumer, for the sale of newspapers, for the provision of gaming and lottery services, for online gambling, and for the provision of accommodation. Then lastly, it will not apply for such other exceptions as may be prescribed. Before I end my presentation, it is key to note that Section 28 of the model then stipulates that the protection provided for the consumers in the chapter applies irrespective of the legal system applicable to the agreement in question. This time I'll leave for my fellow colleague to be speaking on the international instruments on electronic commerce.
The goal of international consumer law on electronic commerce is primarily the establishment of equal standards in the regulatory frameworks of consumer protection in order to enhance the performance of cross-border consumer electronic transactions. The United Nations guidelines on consumer protection still remain the most important global instrument in the area of consumer protection, contributing to the building of trust of both consumers and traders acting on the market. Accordingly, the two principal questions becomes: what is the contribution of the United Nations guidelines to the development of consumer law has been. And the second one being how much the United Nations guidelines have contributed in the practice to the internationalization of consumer law. The main contribution is in raising when awareness is about the requisites of an online trading business laws. It is important that companies doing businesses over the internet are aware of the nuances of international pieces of legislation and when either of the principles is applicable. For example, the following instances are areas where the principles are applicable. Number one, it is important for electronic businesses to comply with the general international guidelines on electronic commerce. For example, the businesses should use fair advertising strategies for the online transactions. Secondly, they should provide correct and accessible information about their company and its goods and services. Number three, they should fully disclose information regarding the transaction's terms and conditions. They should provide a secure method for online payments. And number four, they should protect the customer's privacy during the electronic commerce transactions. The purpose of international instruments regulating electronic commerce is to promote and advance socio-economic welfare of the consumers in the world by outlining universal law to be read and applied together with the domestic consumer laws of any country, and to ensure, firstly, the establishment of a legal framework for the achievement and maintenance of consumer markets that is fair, accessible, efficient, sustainable, and responsible for the benefit of consumers generally. Secondly, reducing and ameliorating any disadvantages experienced in accessing any supply of goods and services electronically by consumers. I'm going to center on the 6 universal principles that are applied to electronic agreements, and these can be used universally and even in domestic policies. Number 1, the users should have automatic access to the agreement's terms. Secondly, the contractual terms should comply with the applicable laws in relation to form, content, notice, and disclosure. Third, the users should be given the opportunity to take some form of affirmative action to consummate the transaction. Fourth, users should be given the opportunity to reject the agreement. Fifth, the agreement process should provide the user to detect and correct errors. Sixth, and being the final one, users should be able to print the agreement, and software developers should provide a method to preserve the electronic records for reference purposes. Examples of the universal application of the laws and the guidelines of the United Nations on Consumer Protection is its reflection in the Zimbabwean Consumer Protection Act, Chapter 1414. Such fundamental consumer rights include, amongst others, the following. A, the right to choose, which is encompassed in sections 18 to 25 of the aforementioned Act. Number 2, the right to information, which is in section 26 up to section 32 of the same Act. And the final one being the right to a fair contractual agreements, where there is no duress, where there is no gaining on behalf of the other party, which is from section 35 to section 51 of the Consumer Protection Act of the Zimbabwean laws.
My presentation is focusing on the aspects that have not been addressed by our legal system of Zimbabwe. Experts agreed that there is no legal system which is perfect. A system of law does not just happen, but it grows. There are a lot of issues which are not addressed by our Zimbabwean legal system in terms of e-commerce. Section 19 of the Data Protection Act provides that places a duty on the data controller to notify the authority within 24 hours of any security breach affecting data he or she processes. However, with the advancement of modern technology, it affected consumers as they will not realize that there is a breach affecting the data, and by the time they will report it, it will be too late. The legislation on e-commerce does not address how victims are reimbursed of their data or money lost, which is one of the loopholes of our justice system in relation to e-commerce. The lack of strong policies and laws that guarantees the protection of consumers online makes anyone's participation in e-commerce transaction a huge risk, with much to be lost in cases of fraud or being shortchanged. Due to those issues which are not fully addressed and resolved in our legal system, people prefer cash because they worry that there is lack of legal protection against issues of fraud. Most jurisdictions and authorities have not yet enacted law governing cryptocurrencies, meaning that for most countries the legality of crypto mining remains unclear, and Zimbabwe is one of those countries. In this scenario, we can give example of a Bitcoin. There is no law and regulation which strictly govern the use of Bitcoins. This is one of the loopholes in our legal system in terms of e-commerce. Further, the use of trade in cryptocurrencies or virtual currencies is not regulated by the country's law, and this graduates to risks such as money laundering, tax evasion, fraud, among others. Hence, these are some of the issues which our legal system have not yet addressed, and they need to be addressed for our own security. I thank you.
Cybercrimes in e-commerce. Companies are now establishing online platforms where people can buy products and make online transactions. To do these transactions, personal information like the name of the buyer, account number, and passwords are needed. Such information and transactions are at risk of being intercepted by hackers. Once one has any of the required person's information, he is able to withdraw money from one's account or make an online payment without the person knowing it. Cybercrime has become an illegal business in the country and is a hindrance to success of e-commerce. In Zimbabwe, billions of dollars are generated from cyber crimes. Types of cybercrimes in e-commerce. Phishing. It is the most common cybercrime in Zimbabwe, and it is a fraudulent attack on the social engines, and in some cases emails come as if they are from friends, as criminals aim to acquire the user's data like passwords and usernames as well as credit card details. The second one being card cloning. Can also be called card fraud. A criminal clones a card and withdraws from a customer's account or makes a payment. Then we have POS cyber attacks. Your point of sale system is the hardware and software that enables your business to make sales. Therefore, malware is installed in your device and the malware is able to get into your system and customers' passwords and credentials. The fourth one being web application attacks. Criminals in this case will penetrate a company's online payment application, put a code that will record all information that the customer enters. The fifth one being insider threats. People working for an organization are potential threats as they have access to crucial information. Insider threats are prone to espionage, that is spying, embezzlement, that is theft of company assets, disclosure of personal information, and stealing of intellectual property. The sixth one being mobile money transfer fraud. In this case, the criminal steals identities in order to register more mobile money for transfers, for example, very own EcoCash. The law comes into action when crime erects. To promote the smooth flow of e-commerce, the Zimbabwean law statutes have done a part in criminalizing cybercrimes and imposing strong and grievous fines and imprisonment for anyone found liable. The Cyber Data and Protection Act. The most important thing to safeguard in order to avoid hackers is a person's personal information. Section 8 of the Act establishes a data protection authority that will regulate the manner in which personal information may be lawfully processed. Section 5 of the same Act introduces cyber security center that will notify areas of intervention to protect cybercrimes. We have the Criminal Law and Codification and Reform Act. The Act also protects e-commerce by criminalizing cybercrimes. Chapter 8 of the same Act introduces cybersecurity center that will notify areas of intervention to protect cybercrimes. We have the Criminal Law and Codification and Reform Act. The Act also protects e-commerce by criminalizing cybercrimes. Chapter 8 introduces computer-related crimes. Section 164 criminalizes deliberate introduction of a computer virus. A fine and imprisonment of 10 years is imposed on one found guilty. Since hackers use malware in POS systems, Section 64 makes it clear that it is a crime. Section 67 criminalizes unauthorized use or possession of debit cards and credit cards. Therefore, the law tries to attack the cybercrime of card cloning. Section 68 criminalizes unauthorized use of passwords and PINs. Therefore, any cybercrime that involves illegally acquiring one's PIN and password is a criminal offense. That is, for example, phishing, POS, cyber attack, to mention a few. The crime constitutes imprisonment not exceeding 3 years. Therefore, Zimbabwean laws try to criminalize these cybercrimes and impose long years in jail so that criminals know the risk and won't indulge in cybercrimes. All this is in the quest to protect e-commerce, which has been quite a target of cyber attacks. Outright theft, loss of potential revenue, breach of customer data are problems that victims of cybercrimes face, and above laws try to make sure there is little or no threat to e-commerce.
Fintech, short for financial technology, refers to software or technology that enables people or business to digitally access, manage, or gain insights into their finances or make financial transactions. The four main fintech areas are digital lending, payment, blockchain, and digital wealth management, and are of particular interest due to their rapid pace of growth. The four main fintech areas are digital lending, payments, blockchain, and digital wealth management that are of particular interest due to their rapid pace of growth, technological disruption, and regulatory and other risks. Deregulation in financial technology substantially increased capital and investment flows in banking and financial markets, which has in turn increased liquidity and reduced borrowing and funding costs significantly. According to G. Walker, Fintech has emerged as a powerful new market force as a result of coming together of a number of disconnected trends. Significant advances have occurred in the areas of computer and digital technology, the internet, mobile telecommunications, as well as economics and finance, which have transformed traditional areas of study and created important potential new business structure and operations. Fintech is creating new opportunities and challenges for the financial sector, from consumers to financial institutions and new entrants to regulators. It offers many opportunities for government, making their financial system more efficient and competitive, to broadening access to financial services for the underserved populations. It also poses potential risks to consumers and investors, and more broadly, to financial stability and integrity. World Bank has been developing specific work programs on fintech as the nature and scope of their members' needs are becoming clearer in response to the Bali agenda. World Bank has been focusing on using fintech to deepen financial markets and improve cross-border payments and remittance transfer systems. The effects of fintech on commercial law. According to George Walker, markets have benefited from substantial advances in all forms of technology, operation including computer hardware and software capability, massive downsizing in circulatory and processors, telecommunications speed and efficiency, mobile access, in particular through mobile telephony, tablets and other handheld devices, and wearable and substantial reductions in manufacturing and services costs. Fintech law regulates and advertising and marketing of new or existing products. This is so customers always receive fair and honest information. The Unified Payments Interface is one of the biggest achievements of Digital India initiative and has made payments easier. It has made financial services available to devices that millions of people have, that is smartphones. And business, it has also improved the POS, that is point of sale system, and they cut down the expenses of businesses, along with gaining sophisticated analytics data to better engage the audience. Thank you.
I'm going to talk about the response of the Zimbabwean law to prejudice in relation to e-commerce. The law in Zimbabwe is active and recognizes the prejudice that may occur in e-transactions. Consumers are afforded the right to have their complaints heard before the Consumers Protection Commission and also before the courts, in order for them to seek a redress through alternative dispute resolutions as it is provided for in the Consumers Protection Act, and also to have representation by persons of their choice. According to the Act, consumers have the right to a fair and honest dealing and protection from unquestionable conduct. The Consumer Protection Act also prohibits suppliers and marketers from using force, undue influence, duress, harassment, or unfair tactics against consumers in marketing, supply, negotiations, or sale of goods or services. Services providers are also prohibited from taking advantage of consumers who are unable to protect their own interests due to mental or physical disability, illiteracy, ignorance, or a general inability to understand the terms. The Act also prohibits service providers from displaying any sign that purports to disclaim any liability or deny a right that a consumer has under the Act and any other law. This includes unfair contractual clauses such as no refunds, no returns, or no exchanges. The Consumer Protection Act Section 33 provides for redress for consumers in the event of disputes or violation of their rights that may be conducted through voluntary arbitrations by consumers protection organizations. In these arbitrations, the Arbitration Act Chapter 715 applies. Where disputes are not resolved in this manner, the Consumer Protection Act also empowers consumers to approach the Consumer Protection Commission. Its functions are to promote, enforce, and protect consumers' rights in the country. Consumers may also approach the courts directly or file an appeal or apply for review. If businesses or service providers are found guilty of failing to uphold their duties in line with the Consumer Protection Act, the courts or arbitrators may take corrective or punitive measures against them, such as imprisonment, fine, or payment of damages for any loss suffered by the consumers.